waste time on everything. Let's come to the subject. Now, I am going to talk on jurisdiction and forum issues in cross-border disputes in Indian family law. Now, very, very quickly, we are 1.4 billion. 35 million plus of us live in 208 countries. We ourselves are 3.28 million square kilometers, 29 states, 8 union territories. In fact, I was talking to a very senior French diplomat. He says, you are as big as entire Europe, but every state is a different country, like Europe. Now, in this backdrop, we have contributed immensely to building up a huge diaspora. But with this has come a baggage of problems. The primary being jurisdictional issues. Now, to understand the concept of inter-country, inter-parental child removal, we don't use the word abduction in India because child abduction is not a wrong, it's not an offense. Both parents are natural guardians. Custody of child is equal with both parents, and you cannot attribute anything. If a parent removes a child, you cannot lodge a police complaint, you cannot even file a civil case because there is no wrong, so there is no remedy. Now, our marriage in the first place is a sacrament, is a religion-based ideology with no element of contract in it. So therefore, marriages solemnized in heaven or marriages created in heaven, solemnized on earth, can only be resolved as per our Hindu law in a court of competent jurisdiction as per an appropriate family law. A dissolution in the US and Europe on an irretrievable breakdown does not solve the problem. So with this backdrop comes the concept of domicile, vis-a-vis jurisdiction. Wherever you go, whatever you become, whatever nationality, citizenship, or temporary stay you adopt, your Hindu law goes on you as a backpack. You cannot say, I am no longer a Hindu. You can say, I am no longer an Indian, which is what happens when you give up your passport and you become a foreign citizen. India does not allow dual nationality. You can become an overseas citizen of India, which is a citizenship not equal to being a full-fledged citizenship. But the fact of the matter is, the Hindu law doesn't go away. So if you are married in India, according to Hindu law, you can only divorce on court grounds or by mutual consent, which has to be done in a court of competent jurisdiction in India. Meaning, where you got married, where you last resided together, where the respondent being the wife resides, or where a man and a woman has not been heard of life for more than 7 years. So what happens? Now, my talk to you will be in two parts. One dealing with jurisdictional issues concerning marriage, and second dealing with jurisdictional issues concerning inter-parental child. So, the introduction and the application of marriage law from the perspective of jurisdiction makes it very clear that you cannot do away with your Hindu marriage by dissolving your marriage by an irretrievable breakdown ground if you are living in a jurisdiction abroad. Most jurisdictions abroad, rather 99.9%, take cognizance of you by virtue of your presence in that country. They say you live here, you are domiciled here, that's all that matters. You are staying here for 3 months, you are staying here for 6 months, you are staying here for 1 year. There is a jurisdiction called GOM in the US, where you can get divorces by post. They don't care whether you live there or you don't, but that is the way of interpretation of those jurisdictions which say you live here, your children are born here, you are permanently settled here. But the point is, where is your permanent domicile? There are Supreme Court judgments interpreting this. If you retain your permanent Indian domicile, minus your nationality, minus your citizenship, the domicile still takes effect. Plus, the Hindu Marriage Act section 1 and 2 says it has extraterritorial application. It goes with you wherever you go. So, if you choose to dissolve your marriage, either by consent of each other or ex-party, or a one-line decree of irrevocable breakdown of marriage, it does not dissolve your marriage. So, all causes of action for dowry, for matrimonial cruelty, for stridhan, for divorce petition pending, child custody petition pending, remain alive. So, if you bring the irrevocable breakdown decree from a foreign jurisdiction, that, if produced before an Indian court, will not end either the matrimonial cruelty criminal case 406, 498A of the Indian Penal Code, stridhan, domestic violence, everything will be alive. Now, issues of child custody and property, again, may be jurisdictional issues. Custody may matter because custody is governed by the Guardian and Wards Act, which specifically states that the petition for custody of a child or a guardianship of a child will be filed in a place where the minor ordinarily resides. So if the minor is residing abroad and one parent has brought the child to India, Indian courts do not get jurisdiction. But again, the Guardian and Wards Act of 1890 is an outdated and a colonial piece of legislation. We refuse to change it. Report number 257 of the Law Commission has strongly advised that we should talk of equal parenting rights, we should talk of equal custody, but we are nowhere near form. We follow an archaic law which is looked down upon by foreign jurisdictions, and according to me personally, it's a very anti-child law. It permits a parent to come to India either violating a foreign court order or violating the other parent's rights, and then obtain an ex-party custody order, depriving the other parent of total access or custody or visitation even, for which you have to enter into a bit of fight. Now, this is an antithesis of the best interests of the child. Parental alienation steps in, and so many other problems. But coming back to marriage and divorce, so how will you settle the matter? I now advocate to all people who do divorce decrees in foreign jurisdictions that you will have to undergo a second divorce by mutual consent based on your foreign court decree. So I now strongly suggest to people that when you are divorcing abroad, please prepare a document separately whereby you will say that we have settled all these matters and all these matters can now be resolved by a decree of divorce of mutual consent in India because of the Indian law applicable to parties. So you bring the foreign court decree, you bring that undertaking, you file a divorce petition by mutual consent together, you get the foreign court decree incorporated into your settlement for divorce by mutual consent, and you get a stamp of an Indian court of competent jurisdiction on the decree, which then permits you to finish matrimonial cruelty, 498A, domestic violence, maintenance, custody, because an Indian court will quash all the proceedings once you mutually settle the matter. So this is one way of doing it. Then the other way is the long, bitter battle, keep fighting for 25 years, come to Supreme Court, and then Supreme Court uses Article 142. Now, Article 142, for those of you who are not familiar with it, is the power of the Supreme Court to do ultimate justice. in any cause of action for any matter. So the Supreme Court uses the ultimate weapon, saying we have been fighting for so long, we are invoking 142, we are dissolving the marriage and we are separating. But then is that the solution? Obviously no. We have to amend our laws. And Justice Rajibala has amply put forth, family laws, matrimonial laws, child custody laws are a very low priority of the government. Nobody thinks of their amendment. Nobody thinks of the implementation. It's a sad state of affairs. I pursued the matter when Justice G. Bala was a judge for 10 years. We did everything in the book. We couldn't give the child back. The child became an adult. The petition was infructuous. Where is the law? The law is not helping children. We have ultimately, realizing that we have done a lot of damage to our children. In 1992, way back, we signed the United Nations Convention on the Rights of the Child, UNCRC. But it took us a long time to incorporate the UNCRC in our domestic laws. When you sign an international instrument, unless and until you make an enabling law within the Indian jurisdiction, you cannot give teeth to the provisions of the international convention. So what we did, we had the Juvenile Justice Act, 2008, 2010, 2012, and ultimately in 2015, the Juvenile Justice Care and Protection of Children Act, 2015, when it came into force, it incorporated the definition of the best interest of the child, which was picked up, which was borrowed from the UNCRC. And I read out to you, it is a very composite definition. And I have started relying on it very heavily in all habeas corpus petitions for the return of children. So what is the best interest of the child? Meaning, in section 2K of the JJ Act 2015, it means that the best interest of the children is the basis, fundamental basis for any decision to ensure the child's basic rights, identity, social well-being, and holistic, physical, emotional, and intellectual development. It's a very wholesome definition. The best parts of the UNCRC have been picked up. The right of a child to a family, the right of a child to a nationality, a home, parents, everything has been picked up and put in the JJ. But this definition of best interest of the child, which is not defined in the which is not defined in the Guardian and Wards Act, which is not defined in the Hindu Minority and Guardianship Act, finds a place. Bear in mind that our judges do not have any statute before them whereby they can interpret the rights of the child. It's a vacuum. There is nothing anywhere. Every custody petition is actually a divorce petition, repeated. The spouses talk of differences between each other. They talk as husband and wife. They don't talk as father and mother. You may be an excellent father, you may be an excellent mother, but you may be a very bad wife or a very bad father. But then transplanting the rights of yourselves and putting the child in a third position is highly detrimental to the child. Justice Sikri in Vivek Singh versus Romani Singh in 2015 first time recognized the concept of parental alienation syndrome. It's a psychological disorder recognized by the United Nations. And it is a very, very strong, ingrained, damaging, deleterious proposition in India for children. Child removed, brought here, guardianship petition filed, rightly or wrongly, ex-party order obtained, other parent comes with a foreign court order. The only remedy to enforce the foreign court order is a habeas corpus writ under Article 226 before the High Court or under Article 32 before the Supreme Court in parents' pituitary jurisdiction, meaning the court with the guardian of the child. So in this jurisdiction, the Supreme Court or the High Court deholds any law looks at the best interest of the child. With the foreign court order, there is only one consideration. Since we are not a signatory to the Hague Convention on civil aspects of international child abduction 1980, we do not have a mechanism to return children on the basis of a foreign court order. We have signed the 1993 Adoption Convention, whereby we have a central authority, CARA, in place, which acts as the processing agency for adoption of children. Now, if we were to sign the Abduction Convention, we would create a central authority within India, which is what we have suggested in the bill and this in the committee's report, which would accept and send out applications and also then forward that application after processing it to the High Court concerned to take a decision whether the child is to be returned or not, or whether Article 13B of the Convention, talking of grave exception, grave risk of the child being returned to the country of its foreign jurisdiction. That is a question which is a judicial prerogative. But the point is, as Bhala put it, we do not have a system in place. And we are not even concerned or bothered about putting a system in place. I appear in high courts all over India, including the Supreme Court of India. Every case is decided independently on how a judge assesses the value or the best interest of the child. That is in case the court is not inclined to send you to the family court for a guardian and what's that petition. That is a simpler way of doing it. But is that the answer? You spend endless number of years, and by the time the court decides, the child is big enough, child is polarized, child is alienated, and what purpose does it serve? The matter will go up to the High Court in appeal, then the matter will come to Supreme Court in appeal. So there are cases where two children are apart, and it's too late in the day. One child is with one parent, the other child is with the other parent in a foreign country, and the court says, we are very sorry, we can do nothing. Is that the solution? We are growing in numbers. We are becoming a major economic destination. We have phenomenally increased our intellectual property in every sector in the world. But when it comes to family matters, we have made no progress. And when a person, a man or a woman, is bothered or disturbed, he will do anything. What is happening now? Children are smuggled out via borders to Nepal or to different countries and smuggled out of the country, never to return. Is that the way? Or children are forcibly brought to India and nothing is done. If a foreign court order is brought, normally speaking, internationally, there is a mirror order jurisprudence, which means an order of a court is brought to India and the court is asked to implement it, mirror it. We do not follow mirror order jurisprudence. We say we will decide the best interest. Though I have, in a matter before the Delhi High Court, in the Tej Singh's case, got a Delhi High Court order, which was, I got mirrored in a US court in Connecticut, giving women all the protections. And even that was challenged by the lady. It went to Supreme Court, and the Supreme Court said, no, you have to go. You have to go back. And literally speaking, now the Supreme Court is saying that if you don't want to return the children, the parent who has brought the child can't be forced to go. You hand over the children and let the children go back. What is being used is now counseling, mediation, and advisory services. My latest matter in Punjab and High Court, I was able to get a child matter settled, two children, born and bred in the US, 10 and 13. Within 10 days, we were able to resolve it. In a habeas corpus petition filed, the judge said, no written reply, no contest, no litigation. Matter is going to a counselor. Counselor did an evaluation in 48 hours, found children totally comfortable with father and mother, wanted both parents to be together. Matter was sent to mediation, 3 days of non-stop mediation, 12-page settlement, everything written down, Women got all her rights. She wanted a house, she wanted maintenance, she wanted separation. Everything sent back, she was went away. So if we are not going to sign the convention, we have to come up with solutions to resolve the proposition in our system by an effective mechanism. Mediation is picking up very heavily. Alternate dispute resolution is coming up very strongly. Every high court has got counseling centers now. There are trained mediators, there are trained counselors. This is an infrastructural support which can help in our system immensely. Now, as far as marriages and divorces are concerned, from the jurisdiction point of view, at least I advocate that when one of the spouses is a non-resident Indian, we should amend our Hindu Marriage Act and bring in irretrievable breakdown hedged with safeguards. It should not be a blanket ground like 13 other grounds in the Fort Principle. You say these are the conditions, these are the provisions in which irretrievable breakdown will be recognized. Why wait for 15 years, 20 years and go to Supreme Court and then Supreme Court uses 142? Why can't we amend our law? Why can't we look at it again? Now, if you go to Kerala, you go to Andhra, you go to Karnataka, high-end IT youngsters get a prenuptial agreement drafted. I started doing it now. They don't want their parents to know, but they say we are going abroad, we can't deal with a messy marriage. They write down everything before they leave India. They get married under the Special Marriage Act, which is a contractual marriage. They do the ceremonial marriage subsequently for the family. And whenever the problem comes, that is the easier way to resolve the issues. Fighting litigation abroad is not easy. It's expensive, it's time consuming, and foreign court judges don't understand Hindu law, family law at all. I am an expert, I have done large number of reports over 40 years in different jurisdictions. They don't understand why the marriage can't be dissolved. What's wrong? In a foreign jurisdiction, divorce is for the asking. Nobody wants to know why, when, where, how. We say no. Adultery, cruelty, desertion. Thank God we remove leprosy now. But that is the way the system works here. So for a foreign court to understand why the marriage can't be dissolved, why father cannot get the custody, why can't the matter be settled amicably, why can't property issues, custody, maintenance, everything be decided? In a foreign jurisdiction, alimony maintenance is 50-50. Nobody is concerned who got it, where did it come from, how it came. In India, we follow the need-based principle. We don't follow the source. So if you are a sick home spouse, you get nothing because you have not contributed. So the spouse who has earned says everything is mine, and the person who has built the family will have to prove that he or she did this, that, and there is no equation, there is no reward for it. So this again, thankfully, in Justice Indu Malhotra's judgment, has brought some semblance of a regime in which assets can be divided in a more better in a Rajneesh vs. Neha is the judgment, which is beautifully brought down. Otherwise, maintenance is an unwritten law. So again, then from jurisdiction point of view, if you are married in India, you divorce in India, you should divide assets in India, is a loser end for somebody who is living abroad because he or she gets nothing. So this is again a jurisdictional issue, which is the next question of law. Now, jurisdiction is a word which has crept in all systems of our family law because we collide with marriage law, divorce law, custody law. Every law is something we are facing in each other. The most recent problem area is intercountry adoptions. We have signed the Hague Convention. We have signed the Hague Adoption Convention in 1993. We have CARA as a central authority in place. But the process of CARA, the process of inter-country adoption, primarily for orphan, abandoned and surrendered children, is good, is tedious, is careful, is appropriate, because an Indian couple, let us say, living abroad, settled abroad, lives in a particular jurisdiction, and they want to adopt a child from India, they have to be checked. And the home country has to do the needful, pass it on to CARA, and then CARA has to process. But what are the Hindu adoptions which take place within the family? Section 56(3) of the JJ Act says that nothing in the JJ Act shall apply to Hindu adoptions. Article 23 and 37 of the Adoption Convention say if there are two systems of law prevalent in a country and the country recognizes it, we have no problem. But then does CARA give you an NOC for a Hindu adoption? No. They make you fight to court. I have fought in practically every high court, and ultimately, now, this is Nagaratna in a matter which I argued. I got success. It was a very peculiar case. A mature lady of Indian origin living in UK adopted twins born to her brother who was separated from his wife. In a Hindu adoption, got into Hindu law. Now, under Hindu law, giving and taking is the only way. No deed, no registration, no paperwork. You can do it, but it's optional. Now, CARA says, we don't recognize this. What do you do with it? They said, now you go back to your country, follow Article 5 and 17 of the Convention, start all over again. What happens to the child which is adopted? That adoption is irreversible. The child has severed his or her ties the moment the child was placed in the lap of the adopted mother. Now, it makes sense in the convention to say that this is the right thing to do, because when an inter-country relative adoption takes place, giving parents taking care, who are the CARA is already there in the form of giving and taking parents. You don't need cross checks. What is CARA? CARA is a system of cross checks and balances. When the system is alternatively in place there, why not? Now, the second issue is the adoption regulations. The word court in the adoption regulations has been replaced by a word called magistrate. Has an executive magistrate got the judicial acumen to approve an adoption? Has he got that lens, that eye of perception? No, a child is not a quota, license or a permit. But this is the way it works. So in every case where there is a Hindu adoption, the parent has to apply to the district magistrate with the registered adoption deed for an evaluation by a welfare committee under the CWC, who will do an assessment as per fill in the blanks in a report. That fill in the blanks report will go to the district magistrate, who will have another fill in the blanks tick mark, check mark adoption order. He will send that adoption order to CARA, and then you try approaching CARA. It can take 2 years, it can take 3 years. If you go in a writ, you oppose it vehemently. So every high court has now started saying, what is the problem? The problem is jurisdiction. The problem is application. So even if we sign the convention, the bottom line is, why should we obstruct? Is CARA meant to facilitate or frustrate adoptions? So this thought perception in the Indian statutory framework that we need to make child welfare laws is very important. I'm one with Justice Dibala. What do we need? We need a children's court. We need a court where these matters can be resolved fast. We did go in that direction when we made the Commission for Protection of Child Rights Act 2005. I was a court-appointed inspection committee head in a very bad child abuse case in Rohtak. And I then filed a petition on behalf of the National Commission for Protection of Child Rights to make Child Rights Commission in Punjab and Chandigarh. It was opposed to thin nail. But then, child rights commissions are supposed to be headed by judges. retired judges at least. If you appoint politicians or you appoint retired government officers as chairpersons of these commissions, outcome is zero. Now, under the Commission for Protection of Child Rights Act, the powers of the Commission to order investigation and inquiry, the quasi-judicial powers are very strong. All matters which come in 226 or 32 can actually go there. And then believing or whatever comes out as the truth, the matter can go to the High Court or the Supreme Court for appropriate directions. So we did take a step forward, but then implementation. So this is a broad bird's eye view. I have 11 books. You can feel free to go on my website, or you can feel free to go on my LinkedIn or my YouTube channel. You'll find me here writing, speaking, blowing the trumpet for India, wherever, whatever, whenever. And I cannot thank Mr. Saku Jacob enough, Mr. Vice President, Mr. Hegde, Mr. Sir Rajendra Singh, whom I have been associated for so long. In fact, it was Mr. Ramnivas Mirza who was actually the private, real motivator of family law or private international law. And Rajendra Singh sir, Mr. Jayaraj, we were people, Mr. Manoj Sinha, we were people who put together so many things. And we all derive our support and inspiration. And Mr. Hegde leads the team. With these words, I am very, very grateful that you have given me this opportunity. And I thank ISL and everybody to be such patient listeners. If anybody has any questions, I'll be free to answer.
Okay.
Yeah, sure.